Good morning, friends. In the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Jawaharlal Nehru Technological University. This case has been reported in 450 ITR at page number 699 and the matter has been decided by Telangana High Court and the date of the judgment is 17th January 2022. In this case, the Assessee is an educational institution. The Assessee applied for Section 12A registration on 30th March 2019. When this application came for the consideration of Commissioner of Income Tax exemption, he rejected the application of the Assessee under Section 12A by saying that the Assessee has not filed the income tax return for that year and the Assessee has also received the income from outside the India, and for that the Assessee has not taken permission from the Central Board of Direct Taxes. So in these for these two grounds, the application of the Assessee was rejected under Section 12A. Now, in the next year, the Assessee applied for Section 12A registration for the second time. As all we know that the registration for Section 12A is applicable from the year in which the application for Section 12A is made. So the second application was made in the previous year 1920, so it was applicable from 2021, and this time the second application was accepted by the Commissioner of Income Tax exemptions. Now the issue before the Assessee was that what will happen for the assessment year 1920 for which the Assessee was not getting the exemption because there is no rule that the exemption will be given retrospectively. So the Assessee filed the appeal for the rejection of the application under Section 12A which was made in the financial year 18-19, that is applicable for the assessment year 1920. When this appeal came before the ITAT said that the second application for Section 12A was accepted on the same facts and circumstances. There seems to be no change in the facts and circumstances of the case, and as per the objectives of the institution, that is education in this particular case, the exemption under Section 12A was granted in the next year. So the ITAT remanded back that matter to the Commissioner of Income Tax exemption with the direction that if he finds that the facts and circumstances are the same for both the years, that is for the assessment year 1920 or the assessment year 2021, or the facts and circumstances when the application was earlier made and when the application was made the second time. So if the facts and circumstances are same at both the time, because the objectives of the institution were very clear that they were of education nature. When this application was remanded back to the CAT exemption, the department moved to the High Court against this order. The High Court also said that by upholding the order of the ITAT, that the ITAT has not made any mistake and the exemption to the Assessee should be given to the Assessee for the assessment year 1920 if the Commissioner of Income Tax exemption feels that there is no change in the facts and circumstances of the case and the Assessee was fulfilling the requirement of Section 12A at that time also. Because when the application for Section 12A was accepted in the next year, the objectives of the institution were seen and they were the same objects which were at the application was made for the first time. So friends, this case is very important because at many times it happens that the application for Section 12A is rejected. So there is always a question in the mind of the Assessee whether for apply for the second time registration or for go for the appeal. So according to this case, it also comes out that the Assessee should make the second application and at the same time the Assessee can move the application under Section 12A and go for the appeal to the ITAT for the rejection of the earlier application. Friends, this case is very important as far as the rejection of section 12A applications are concerned and the way which the assessee should take, whether he should go for the appeal or whether he should go for the second application. So this case gives the hint that we can opt for both the options. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Jawaharlal Nehru Technological University. This matter has been reported in 450 ITR at page number 699 and the matter has been decided by Telangana High Court. The date of the judgment is 17th January 2022. Thank you, friends.